Catherine.
She got one. Catherine has
So
two.
we got one.
I wasn't
And
thinking about
her, his client, right? He forget.
You didn't get that on the record.
So everybody got one, right?
Everybody good?
Yeah, we can take one back.
All rise. Hear ye, hear ye, hear ye. This Honorable Division of Criminal Court 10. The 30th Judicial District of the State of Tennessee is now open for the transaction of business pursuant to adjournment. All persons having business with this court draw near, give attention, and ye shall be heard. The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
Good morning. Any business we need to take care of before we bring the jury in?
Hey, how y'all doing?
Hello.
Welcome.
Evans, you'll be up first.
Yes, Ron.
Closing, and
You
ready.
can bring in the jury.
That was the young Dolph first trial.
Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's gonna take me about 15, 20 minutes to read this charge. So if you don't feel like you're gonna be able to sit still during this time frame, please exit.
Ready now? Jury time, enter into the courtroom, y'all.
Good morning. Good morning. I trust again that everybody has a good night. Mr. Evans, can you call your first witness?
Your Honor, the defense rests.
Ladies and gentlemen, you have heard the proof in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it and you all have to read it at the same time. Okay? That is your copy. Feel free to write on it. I have the official copy here that will go back with you to the jury room. I cannot write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. State of Tennessee versus Justin Johnson. Members of the jury. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit first-degree murder. Any person who commits the offense of facilitation to wit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the results will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pleaded not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempt to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulation. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Hold on, excuse me. I have a phone call. She thinks you're too young.
Good morning.
You're too young.
Morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Govan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph security for years. He was able to identify Dolph's car in the beginning of the Makitas video. And he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They changed their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. Okay. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Nikita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well, actually, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Akiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the convicted felon in possession of a firearm. The three things that we have to prove beyond a reasonable doubt is that one, this defendant was a convicted felon or convicted of a specified felony. And two, after being convicted of a felony, this defendant possessed a firearm. And three, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, one, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to well at night. Will you be able to? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well, actually, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams.
Thank you, Judge. It's good to see y'all again. This is the last time you're gonna have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible. And the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. Now, on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on La Bradley. Engaged in a music video, right, for his rap. hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial, hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith, that conscience, right? Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He did. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Ford Jr. He didn't conspire to kill Adolph Ford Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that, to watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it, other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments. You look back at the Makita video, those are the same underwear. Look at it. Look at the still shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree, right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics, right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas and goes, "That's not me in the video." And he's like, "Okay, it's me." But what they're trying to tell you, Justin Johnson's at the Valero gas station, right? When he's pumping gas. Where is he? Now they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Horton Jr. Their prints are in the car. He says they have, he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, I don't have anything to do with this? And at Valero, you do see Trayon Ingram and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be and he said could be, he said was in the service area of the Valero gas station, or then he said, I didn't do any drive tests, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time immediately after Adolph Horton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important when there are a group of fine people that are looking to find the truth and have to make this decision. and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Juk, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to determine, talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told him. He had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, and it was kind of an interesting moment when he was testifying, because at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom. And I asked him, I said, you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Service is rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Ali Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. I was trying to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. Had to have a technician. It's a computer. I don't understand it. But when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelius Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. You know, and all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right? For you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is your job to find the truth of the matter, and ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience back there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard the statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt, right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it.
A missing witness? Hernandez Gomez? Absent material witness. And the defense wants to say that is Hernandez Gomez? What do we know about Hernandez Gomez? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe it? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's called. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, he didn't pay for the car. They're riding around with guns in a stolen car and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting them. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison. And Justin Johnson's the guy next to me doing it. Case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we had a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of a white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valero. And they switched cars. That's corroboration. So do you have to be willing to trust Kissing Gardner with the keys to your car? Of course not. You think I trust Kissing Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because on video of Valero, it's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissing Gardner's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I miss a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Sons. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, like, real tricky truth test. Justin's driving the white Mercedes. You see the video, of course, where he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. We're saying it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the Two Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax car, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do in trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after this shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down for this. It's number 2 with C and G. Guy that put hits on the other artists too. Cornelius says, now Dolph with your hands. And what do we find in Justin's phone? I mean, delete the stuff all day long. He did. Whole day. November 17th. Deleted all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. With Big Joke. Cornelius tells you. And there you see it in black and white. It's not 1981. That's true. Call and camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left across at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis talk, all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder. The Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Big Joe. Caught before, caught during, and then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we have? Another Memphis phrase. Get on down. Get on down. Cross town the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, on manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Brilliant. Brilliant. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Joe or something. That's why I just started, let's cut a little break on the conspiracy of murder, because he's not at this meeting with, Big Jug and Govan and Cornelius. So let's cut a little break on that. That's what I heard. Let's cut a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jug is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets on, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break, no. He's guilty of the conspiracy, just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one lyric. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long was the videotape? 30 seconds? You're too real. Dies on the floor. A neighborhood cookie store in Orange now. It's real. You're too real. Your family misses you. Erica and Mia and the kids. You too real. This is real. This is too real. And when the killer, 1 to 2, is caught on video, all the times, we even watch it get on down, it's time for us to be real. No, we don't need Memphis to talk for that. It's called just do what's right. It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Thornton Jr. November 17th. We watched it happen. Cornelius Smith, Justin Johnson, Hernandez Govan, Big Jug, they all conspired to have it done, and it was done. November 17th, 2021. And as he did it, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
All right, ladies and gentlemen, I got a few more pages of the charge to read to you. I'm gonna pick up on page 29. Verdict. Count one. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder. When you retire to consider your verdict in the first count of the indictment, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count one of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count one. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count one of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. The verdict will be: we, the jury, found the defendant not guilty as to count one. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count two. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of first-degree murder as charged in count two of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of second-degree murder as charged and included in count two of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count two of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, first-degree murder, as charged in count two of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, as included in count 2 of the indictment. Insert the lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be, we, the jury, find the defendant not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm as charged in the third count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the third count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdicts will be, we, the jury, find the defendant not guilty as to count 3. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. Can I have the jacket, please? You will have all of the exhibits. We'll go back with you. Please look them over. If at some point you want to watch videos, please let us know. Do you have did you make the list? Okay,
It's been numbers and exhibit, Your Honor.
Okay, so it's with the exhibits. Do you have a clean laptop so they can you get us a clean laptop so they can watch videos as they want to watch
They'll get
videos?
it, Your Honor.
Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos. And there will be a list accompanying the video to show you, to tell you, describe to you which video is which. Does that make sense? Okay. So, is everybody in good shape to deliberate? You getting ready to choose alternates? Everybody good to deliberate? I'm going to call three numbers. Once all three are called, the deputy will escort you back to the back to get your belongings. And then if the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberations. Okay? Juror number 18. Juror number 13. And juror number 12. You guys can look at these if you'd like. You can review these. If you'd
Oh,
like.
yes, sir.
Oh, no.
Just always. You can read. Just make it a point to let you show me.
Yes, Your Honor. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over here eating and the rest of you are deliberating. If you decide you're gonna eat, everybody eat. If you decide you're gonna take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay? Jurors, you are excused.
Bring everything with you.
Court stands in recess.
Court stands in recess.
Hey guys, so we we got the verdict in. I'm going to put the verdict up. I'm gonna run the verdict. As you already may know what the verdict is, I am going to
We have a verdict to the members of the public. If you don't think you're going to be able to not show any emotion during the reading of this verdict, I ask you to remove yourself now. There won't be, the court won't tolerate any outbursts of any sort from anyone. Anything you do?
Ready, Your Honor?
Yes.
Jury is now entering to the courtroom.
Ladies and gentlemen of the jury, have you reached a verdict?
We have your honor.
Four person? If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict?
Yes.
Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes.
Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you made. Thanks again for your time and attention. You are excused.
Jurors excused.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be November 1st.
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet and pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
Sir, let's get that, we'll get those to you.
Thank you. Give me a turn for it.
All rise. Justin Johnson's was.
Yeah, so you got the facts you got the evidence you got. We heard testimony that the car had been wiped out and clean, and we know it was moved and everything else, and we were able to explain to the jury why those three individuals' fingerprints were in that car. And so I mean, the jury heard all the proof and they understood it, and I think we painted a real clear picture of both before, during, and after the murder. The investigation did a fabulous job of highlighting sort of all three of those times and answering a lot of questions that a lot of murder cases you never get answered. We had a strong case, so it was good.
And I'd like to add also, I should also be complimenting the law enforcement investigative team. They did an excellent job in this case, and I don't want to leave them out. You don't always get fingerprint evidence. You don't always get DNA evidence in every case, and it is certainly possible to prove a case beyond a reasonable doubt with any of that. And the proof in the pudding is what happened today.
Now, we haven't heard from the family, understandably so far, but you have worked closely with them. What have their emotions been like throughout the trial, especially today, given that news?
Well, in the trial, during this trial, they have been patient and they've been together the whole time, and they small little room they're in before they go in the courtroom. I know this thing's been hard for them, but they've been a unit and they've been, solid with each other and solid with us during this trial. It's a hard trial, and they've been great during it.
You made a point in there to highlight how corroborating evidence was one of the most important aspects of your case, and the fact that witness testimony lined up with corroborating evidence. That.
Well, it's just so important. I mean, I think that sometimes when you try, particularly violent cases like this, sometimes your witnesses are not the best characters. I think, like I told the jury, there's many witnesses over the cases I've tried through the years. I wouldn't trust them with my car keys or whatever else. But when you can point to other evidence that corroborates their testimony and their account, proves to you that what they're saying, despite who they are, is true, then that's incredibly important in a trial.
This has been a long time coming for obviously the family of young Dolph and fans as well. I guess, what would you say to them now that there's a guilty verdict?
Well, I mean, what I would say is that justice has been done, at least so far. And our efforts will continue to make sure that everybody who's responsible for young Dolph's death is held accountable. You've seen us do that so far with two defendants, one by guilty plea and one by guilty verdict. And our work will continue. Take maybe one more question.
What's next for Cornelius Smith?
Mr. Smith's case will be reset until November. Like I told the jury, like I told the court, there'll be a point where he goes to prison. But we'll have to wait.
So thank you all very much. And the family has said that they are available to talk to you. And so I certainly encourage you to do that. Thank you all very much.
Oh, I'm stepping out. Here they go.
Since it's a 2 or 3, keep going. Yeah, it's a 3. Just turn it off, just turn it off.
I got you. What's wrong?
No, I did better than my spokesperson.
On November 17, 2021, our lives changed forever. A son, a father, a brother, a friend, a businessman, a music artist, a philanthropist, and life partner are all among just some of the titles that my brother Adolph Robert Thornton Jr. held. Titles that have now left a missing piece in the lives of so many. I want to say thank you to the jury for their service and decision in this case to bring us one step closer to justice for our family, friends, supporters, and the community that has supported us during this time. Thank you to Judge Mitchell, Shelby County District Attorney's Office, including Paul Hangerman and his team, the MPD, U.S. Marshals, Tennessee Bureau of Investigations, and other investigators and staff that assisted us with this investigation and case, ensuring that those responsible for this crime and involved with this crime have and will be brought to justice for their actions. We realize this act of violence has impacted so many outside of our family and friends. Your outpouring of love and support throughout this process does not go unnoticed. We ask that instead of focusing on those who committed this crime, you focus on the man that Adolph Robert Thornton was. Regardless of the name that you may know him as, such as Adolph, Dolph, or Young Dolph, we ask you to remember the man who enjoyed being a father and spending time with his family. We ask that you remember the man who enjoyed giving opportunities to those who were often overlooked and counted out. We ask that you remember the man who enjoyed giving back to others and being an inspiration to those who come from less than ideal backgrounds, and knowing that they are seen and can change their outcomes and the lives of others by doing something positive. We will continue to heal and keep Adolph's legacy alive. We ask that the public and the media continue to keep our family in their prayers, as well as continue to respect our privacy during this time and the next steps of the judicial process as justice is served for all those involved for our loved ones. Thank you.
There was Carlisa Thornton, girl sister, she didn't say what her name was. The correct spelling of her name is Carlisa. Carlisa Thornton, sister of Young Doctor.
Thank you.
Is it younger sister?
Just sister.
Just sister,
I don't know if
okay.
it's younger or older, just sister. On what?
That's what I was thinking.
I was able to find a bite for prognosis that Central's not going that past a certain time. I was able to find a bite from Central. go to find out, but I don't remember if I saw it.
First guy out of the car, who's that?
It's me.
That's you? Which one of the guns do you have?
I got the little Draco stairs one.
Okay, that's that semi-automatic weapon, is that right? You ever shot that thing before?
I ain't no shit.
Okay.
A beloved rapper was gunned down in broad daylight during an ambush nearly 3 years ago. Now, one of the rapper's alleged killers faced trial for his shocking murder. On November 17th of 2021, Adolph Thornton Jr., better known by his stage name Young Dolph, was visiting a Memphis bakery that he reportedly loved visiting when he was home. While there, 2 gunmen in a white Mercedes-Benz ambushed him, shooting him several times, killing him. An autopsy reportedly revealed young Dolph sustained more than 20 gunshot wounds, some of the bullets hitting young Dolph in the head and back. Young Dolph was a beloved fixture in Memphis, many noting he wasn't just a great rapper, but also was one to always give back to his community. His murder left the city and rap fans in shock and disbelief. Some city officials even expressed fear the shooting would prompt retaliation and plague the city with more violence. After the shooting, many questions lingered as to who could have done this. Not uncommon in the rap game, Young Dolph did have feuds with other rappers, including Memphis rappers Yo Gotti and Black Youngsta. A few years before his horrific death, in 2016, Young Dolph released his debut album, King of Memphis, which Gotti and Black Youngsta took offense to. It led the latter to leading an armed group attempting to find Young Dolph in Memphis. Then the following year, Dolph released a diss track against Yo Gotti, and after shooting the music video for the song, his car was shot up, but in that incident, no one was hurt. After that shooting, Black Youngsta and 2 other men were arrested, but the charges were dropped due to insufficient evidence. Then a few months later, in September of 2017, Young Dolph was shot multiple times outside a store in Los Angeles. Yo Gotti was named as a person of interest in that shooting, but was later cleared. So when Young Dolph was murdered in 2021, some rap fans theorized he may have had something to do with the shooting. But on January 5th of 2022, police ID'd one of the suspects responsible for Dolph's murder, one being a then 23-year-old Justin Johnson, who was ultimately charged with first-degree murder. His half-brother, Jamarcus Johnson, pleaded guilty to 3 counts of being an accessory after the fact, allowing him to avoid trial, but he could testify against the other murder suspects. Another man, Cornelius Smith Jr., was also charged with first-degree murder and pleaded not guilty. And Hernandez Govan was also arrested in connection to the rapper's death. He's alleged to be the mastermind behind the shooting. But the first suspect to go to trial was Justin Johnson. During the prosecution's opening statement, they painted the murder to be a well-orchestrated and sinister plot. The state started off with showing jurors the chilling surveillance video from outside Makita's Cookies, where young Dolph was murdered. The video shows the rapper alongside his brother pulling up and going inside the bakery, seemingly unaware they were being followed at that particular moment. Then about 30 seconds later, a masked gunman jumps out of the passenger side of the car and runs toward the store.
It's a stolen car that our defendant here, Justin Johnson, traded for one car for another at a gas station about 10 hours before this murder happened. This man got out of the passenger side of the white Mercedes. Door's still open. We saw him run to the parking lot. He's here with a large semi-automatic weapon. He's in a hoodie. He's got sweatpants, and he's got white shoes. We'll see a second man come out of the car too. Those 2 men that we're going to see come out of the car, they're going to gun Dolph down. He's inside the business. He has walked over to sort of where the bathrooms are in the business. He's as close as I am to y'all. There's the window, and he's getting shot through the window. Both of these men will shoot. This one in particular, it looks like he's never shot this type of gun before. It's because he probably hadn't. The second man out of the car who's driving is our defendant, Justin Johnson. This is Dolph here. Remember, he was wearing wearing the yellow. This is Marcus. Remember I told you he had a gun. He tries to return fire as these two men quickly shoot Dolph. Dolph's body's riddled with bullets. He shot all in the back, in the face, in the neck, in his arms. The first man out was Cornelius Smith, and he has that semi-automatic weapon, shooting wildly into Dolph. The second man out was Justin Johnson, who has a handgun, who's firing at Dolph as he lays on the ground.
According to the state, Justin Johnson and Cornelius Smith didn't even know each other that well. And what brought them together was Hernandez Govan, better known on the streets as Quet. And in a courtroom shocker, the state alleges a man named Big Jook, who is the brother of rapper Yo Gotti, had a hit out for young Dolph for $100,000. Big Jook, whose real name is Anthony Mims, was considered a leader at his brother's record label. He was gunned down in January of this year, but he would be a focal point in the prosecution's case.
The business is not just rap. Because Big Jook, person I told you about before, that number 2 guy at CMG, he's put out a hit. A hit. $100,000 to whoever kills Dolph. He has met with Justin. He has met with Cornelius. And they think they're ready to do it. They're definitely willing to do it. For Cornelius, it would be 50 grand, I guess, that he could waste away on Percocets and ecstasy. For Justin, it's 50 grand, but also a chance to make it big with CMG. They're not professional hitmen. Not even monsters. I'm not going to call anybody a monster. This is just business for these two. Money for Cornelius, money and rap fame for Justin Johnson.
According to the prosecutor, the alleged killers tried to cover their tracks. They used a stolen car, wiped it down and ditched it. They wore gloves to not leave fingerprints and got rid of the guns used in the murder. But one thing they didn't account for was surveillance cameras. When it came to the defense side in their opening statement, Johnson's attorney said his client is innocent.
You heard a little bit about Govan, and I anticipate you'll get to hear from Govan in this case. You already heard you're going to be hearing from Mr. Smith. You know, and Mr. Hagerman talked about Mr. Govan and said he liked to, you know, get an interest in young rappers, right? He liked to exploit. He liked to exploit young rappers. Like Mr. Johnson. What you're going to hear is as the process goes on, is the idea is that he's going to sign with CMG, Mr. Johnson is. But there comes a point in the road where what Mr. Govan wants, which is a meal ticket, the payday, and what Mr. Johnson wants, different. And you're going to hear about how they take this trip to Atlanta. And the whole idea is that they're going to go to Atlanta, and this is Mr. Govan's chance. He's got another guy he's going to bring in to help sell the management contract, which is going to give him this massive piece of this young up-and-coming artist. And you're going to hear, this is about September of 21. This is right before November. And you're going to hear that they go to Atlanta to meet Jook, who is one of the higher-ups at CMG. Right? They go to Atlanta, and while in Atlanta, Mr. Johnson decides, I'm not going to go your way. I'm not going to go your way, Govan. I'm not going into business with you. I'm going to do it without you. And at that moment, I anticipate you're going to hear Mr. Govan say he was really mad. He felt some kind of way about the fact that he had, in his mind, his perception was he had done all this to help this up and coming star, and now he was going to be left to the wayside, and he wasn't going to get a piece. And he's so angry that he leaves Mr. Johnson in Atlanta. Leaves him there. Mr. Johnson has to find another way home. When you hear witnesses like Govan testify, why is he saying what he's saying? What's he getting at? He's getting something, and you're going to hear it. He's got a vested interest in making sure that he saves his own hide and takes this young rapper, this young man, off the board, since he wasn't going to go with him in the first place, since he abandoned him and decided not to share any of his money going forward.
The first witness called to the stand was young Dolph's sister, who elected not to be on camera, but testified the two had a close relationship.
When was the last time you saw your brother?
The last time that I saw my brother was in September, right before Labor Day. So 2 months before he was murdered.
Okay. And you did find out that something had happened to him?
Yes.
Okay. Did you know of any funeral service of Mr. Thornton?
Yes, I planned.
Okay. And did you attend?
Yes.
Okay. My final question, do you miss your brother?
Most definitely.
Okay.
Her testimony was brief, and the defense chose to not cross-examine her. So next on the stand was Raul Hopkins, aka Blue, young Dolph's longtime friend and security manager, who also elected not to be on camera for his testimony. The prosecution says Dolph's murder happened because of the tension between his record label Paper Route Empire and Yo Gotti's Cocaine Music Group, or CMG, which Hopkins said the feuds escalated to violence.
Are you familiar with the name Jook or Big Jook?
Yes, sir.
And is that person, to your knowledge, affiliated or part of the leadership of CMG?
To my knowledge, yes, sir.
In his rap songs, did he call out CMG and those artists?
Yes, sir.
In those rap songs, in fact, did he call out Big Jook?
Yes, sir.
Did he say insulting things about Big Jook?
Yes, sir.
Through the years, has that translated into some violence directed against Dolph?
Yes, sir.
You mentioned 2 incidents. Is that right?
Yes, sir.
To be clear, these are incidents that happened in the past. Is that correct?
Yes, sir.
Mr. Johnson, who's on trial now, was not part of it.
No, sir.
Tell me quickly about those 2 incidents.
1 and 15, we was in Charlotte.
What happened in Charlotte?
We just came to the hotel. We was in the Sprinter
van?
Sprinter van, yes, sir. We was sitting there for about 15, 20 minutes. Ran upstairs. Once we got upstairs, got in the room, 2 more people ran up and said they just shot up by Sprinter.
Bullet holes?
Bullet holes.
A lot of them?
Yes, sir.
Did Dolph end up even rapping about it?
Yes, sir.
An act of CMG violence.
Yes, sir.
What was the other incident?
The other incident happened in California when he actually got shot
Dolph got shot.
in California.
Perpetrators affiliated with CMG.
Yes, sir.
Next on the stand would be a key witness with inside knowledge into the beloved rapper's murder.
We cover a lot of horrific and tragic stories here at Law and Crime, but what keeps us bringing you these types of stories is in part due to our great sponsors. And for all the business owners and those who are interested in starting a business or even a side hustle, listen up, because I'm going to introduce you to a great platform, and that's Odoo. Odoo is a free all-in-one business management software that provides you with a range of applications that helps with the day-to-day of owning a business. One of my personal favorite Odoo applications is their customer relations or CRM app, With this application, you can easily create quotations to send sales orders to clients in just a few clicks. It automates the process, making it super easy and super simple, and these quotes look clean and professional. This feature also has an internal notes tool, which helps keep track of every activity through the sales/CRM process so that there is transparency and clarity for your team members as well as yourself. So again, we want to thank Odoo for sponsoring us here at Law and Crime News and giving us access to their platform. So right now you can click our link, www.odoo.com/LCnews, and try Odoo now for free.
Cornelius Smith, who admitted to being one of the gunmen, took the stand as a witness for the state. Like the witnesses before him, through his lawyers, cameras were instructed not to show his face due to security concerns in the jail. During openings, the defense cautioned jurors not to believe what Smith had to say, but Smith himself said on the stand he wasn't offered any type of deal for his testimony.
Have I told you that it's very important, though, for you to tell the truth?
Yes, sir.
I told you it's important to tell the truth because I said so,
Yes, sir.
and because the judge will evaluate whether or not you told the truth.
Right.
And have I told you it's in your best interest to tell the truth?
Yes, sir.
Are you here to tell the truth?
Yes, sir.
I want to skip forward. Okay? We're going to go back to everything, but I want to skip forward. Tell me about the day that you were arrested for this case.
It was my daughter's birthday, actually, and I was out. I had took her some cake and ice cream to school for her birthday, and the U.S. Marshals they were trailing me the whole time. I didn't know that they were trailing me because I had saw Goban the day before, and he was telling me that, police was on to us or whatever, and he asked me when the last time I spoke to Justin, and he was saying, I was like, it's been a minute. So he was like, they just ran in Justin's spot the night before, and he said that they been shooting at him, and that I need to get rid of my phone because they own us. And the next day, I was locked up, like,
Police captured you? Police captured you that day?
Next day.
Did they get your phone that day from you?
They didn't get it from me. I left it with my children's mother. Whatever.
They get your phone from your children's mother?
Yes, sir.
So you didn't throw it away like Govan told you to?
Nah, I ain't threw it away. I gave it to her.
Now, when the police first arrest you, I mean at the very start, do you say, hey, I want to tell you the truth about this whole thing?
No. I ain't never did it.
At some point after you're arrested, did you decide to tell the truth?
Yeah, once I came to my senses and Justin had wrote me a kite. Somebody. See, Justin.
So let me tell you, when you hear another lawyer speak up and object, it means you stop talking. Okay? And you'll be instructed to either move on or to another question. Okay?
And I think some rejection is going to be hearsay. So let me try to get you. Let's try to back up, okay? So you said after you arrested, you came to your senses. Right. Is that correct?
Correct.
And you say that Justin, is that the defendant in this case?
Yes, sir.
Had written you something that you called him.
A kite.
Okay. Okay. Without saying what was in that kite, and that's a letter, is that right?
Yes, sir.
Without saying in that letter, after you received that letter, did you decide to tell the truth?
Right.
And what did you do once you decided to tell the truth?
I had spoke with my lawyer.
And thereafter, have you met a few times with detectives?
Yes.
And have you met, we count those 2 minutes right back here, I guess 3 or 4 times with me, is that correct?
Yes.
Would it be fair to say you did that because you realized you had been caught?
Yeah, I've been caught and I got a conscience too. Now they don't know where my senses. Yeah, I got a conscience.
Prosecutor Paul Hagerman replayed the security footage from outside Makita's Cookies, and Smith, while on the stand, made another shocking admission.
That's the day that we had saw young Dolph and them pulling in Makita's.
All right, so whose car is that?
That's young Dolph's car.
All right, and you say we, who saw this car?
Me and Jessica.
Well, let's back up then and tell me, how do you know Justin?
Through Govan.
All right, and who is Govan?
Ananda Govan Quick. We know him by Quick.
Okay, who is Quet?
Associate.
How is it that you met Justin through Quet?
Just, like, being around, basically. Being around.
Would Justin be around Quet too?
Yeah, he'll be around Quick.
Do you know why Justin would be around Quet?
They look at each other like brothers, brothers, and then just rap or whatever.
All right, you knew Justin to be a rapper?
Yeah.
Did you know his rap name?
Straight drop.
And did you know Quet to be involved in, I guess, the rap business or something?
College still.
Okay.
College still.
What sort of would he call himself as far as being in the business?
I guess a negotiator. I don't know.
A negotiator?
I don't know. Yeah.
Okay. Do you know whether or not he was trying to negotiate for a straight drop?
I guess trying to get him a deal.
Okay. Do you know who he was trying to get him a deal with?
Big Juke and them got in him.
All right. You said Big Joke, is that correct?
Yeah.
You ever heard of the music label CMG?
Yeah.
Is that Big Jokes?
Yeah, Big Juke and them.
And his brother, right?
Yeah.
His brother's Gotti, is that correct?
Yeah.
So how did you get to be with Justin Johnson this day on November 17th, 2021?
We knew that, they had heat on Dolph and them head or whatever, so.
Who had a hit on whose head?
Big Juke had a hit on Dolph head or whatnot, so.
How do you know that Big Joke had a hit on Dolph's head?
I could quit had told me about it, quit, and I was in being just
How much money was it supposed to be?
100,000 on Dolph head.
And had you agreed to do this hit?
Yes, sir.
Had Justin agreed to do this hit?
Yes, sir.
We all gonna do it together?
Yeah, they been on it, but yeah.
Was there any arrangements as far as splitting money or anything?
Yeah, me and him supposed to be giving Quit 10,000 apiece.
All right, so you and him were gonna give Govan 10,000 apiece?
Yeah.
And how much were you gonna get?
I was getting 40, he was getting 40.
Smith admitted to only knowing Justin for a few months prior to the shooting and admitted the two followed young Dolph after spotting his car in Memphis on the day of his murder.
So y'all,
Yeah, that's us right there.
stop it here. First guy out of the car, who's that?
That's me.
That's you? Which one of the guns do you have?
I got the little Draco stab on.
Okay, that's that semi-automatic weapon, is that right?
Yeah.
You ever shot that thing before?
I ain't never shot that one.
Okay. You can proceed, Irish. That's your gap hoodie, is that right?
Yeah, that's me.
That's you. Who are you shooting at?
Done.
All right, now back it up again, Miss Irish, if you would. Back it up for Justin getting out of the car. All right, who's the second person here that got out of the driver's side?
It's just,
He's got the smaller handgun, is that right?
yeah, bad baseball, hey, bad pro baseball.
You're firing this crazy thing. What you see? What are you feeling?
I wouldn't feel nothing at the time, but I ain't gonna even let it. I wouldn't feel nothing at the time. I was just, trying to get some money.
Smith testified at the time he didn't notice young Dolph's brother firing back at them until he was struck by bullets in his shoulder and his leg. After fleeing from the scene, Smith said they ditched the car and were picked up in an expedition where Justin Johnson FaceTimed Big Jook to let him know they were responsible for the hit on young Dolph.
And you said somebody spelled out Dolph. Who spelled out Dolph?
Just spelled out Dolph.
When you say spelled out Dolph, what do you mean?
Like the sign language.
With
Jailhouse sign
with,
language.
like this would be an O?
Nah, yeah, I think I don't know how to do it, but
Okay.
something like that.
All right, so there was some signing, then y'all just took care of Dolph. Who's that? Short call, long call?
It was short.
Driver just got out. Who's that?
It's me.
You got your shirt all messed up, don't you?
Yeah.
Why is that
I'm bleeding. I'm shot.
in the shoulder?
Yeah.
Go, and we saw somebody get out of the passenger side, is that right?
Yeah, it's just.
All right, you can play a little further. Gray sweatpants, black hoodie, and that hat we saw is Justin, is that correct?
Correct.
But under cross-examination, Johnson's attorney hammered Smith about his recollection.
You started out with a different lawyer and you ended up with the lawyer you have now, right?
No, sir. No, sir. He was never hired.
Okay, well, you got paid.
No, he did not get paid.
Didn't you get paid?
No,
Didn't you get $50,000?
he did not. He ain't signed my jacket saying he represented.
That's not what I'm asking you.
I just talked to him.
That's not what I'm asking you.
Right. You asked me.
He got $50,000.
Oh, wait a minute.
Lawyer. So.
Hold on just a second. Ask your question, wait for the response.
The original lawyer in your case got $50,000 to represent you. Did he not?
I don't know exactly how much you get. I don't know. I
Okay.
can't say.
All right. And you knew that, just we're all clear here, that money came from CMG, right?
Yeah, I don't know exactly who, but yeah.
All right. So you talked today, you got paid for what you just testified to, didn't you?
After I was locked up,
You got paid,
my
right?
lawyer was paid. Lawyer.
You got $50,000 to pay a lawyer, right?
I didn't get it in my hand. Great. I don't know how much it was, but great. My lawyer.
Okay. And there's no question that that money was for services rendered. Killing Dolph.
Basically.
You took it, didn't you?
Yeah.
Did your conscience bother you?
Come on.
Your conscience.
After I came to my senses, yeah.
Did you say, I can't have that money? I can't use that money, but you still got a lawyer here.
Nah, I ain't say that.
You took the money.
Yeah, I took the money. I got the money.
Your conscience wasn't bothering you that bad, right? You said your conscience started bothering you, but not bad enough not to take the money for the job you did.
Well, I had already did it, so might as well. You know, I got a conscience still. After I came to my senses.
Right. Okay. So, you didn't think, man, I really shouldn't be able to keep money for killing somebody.
I didn't think like that.
Okay. Now, at the end of this, you said, you're direct. You said something about, you saw a picture of the person, you said Mr. Johnson with a suitcase. And you said, he's there with his money, getting out of town.
Right.
To be clear, you don't have any direct knowledge of Justin Johnson getting a dime for this, right?
Nah, I ain't got nothing.
Okay. You said you had a change of heart and your conscience started getting to you. You wanted to tell the truth. When did that happen?
Like a couple months after I sobered all the way up, while I was in jail, so all the way up. I ain't in my senses like it was wrong.
Okay. So you got December is when you go to jail. December 9th.
Yeah, December 9th.
So a couple of months from then, you sober up. That's when you come to your senses.
Yeah, and then Justin had sent me a letter saying.
Well, I'm not asking you what Justin sent you a
I'm
letter
saying
saying.
what automatically made me come to my senses and like, you know, it was wrong. You know what I'm saying? When he said, cut him loose, take the juke, and quit down with me.
Okay. So you're saying Mr. Johnson sent you something saying, he actually said he didn't do it, right?
Now, he didn't say he didn't do it. He said, cut him loose and take the juke and quit down with me because they ain't messing with us.
Oh, you mean tell the truth? Right? Because he didn't have anything to do with it. Tell the truth.
Nah, he's saying me take the downfall.
Oh, okay.
Cut him loose, let him go.
Okay.
And tell them get quit and him change clothes and quit with me instead of him.
Okay. Let me ask you this. Did you get it directly from Justin Johnson, this kite you're talking about?
You know, we got rock meeting still, but we were talking through the vent. I was in E part, he was in E part. We were talking through the vent.
Did you get it directly from Justin Johnson?
Nah.
Did you see him write it?
Did I get it? He said, did you get it? Did you get that kite?
Did you see him write it?
Nah, I ain't see him right. I mean, another part.
Right, you can't even see him.
When he asked me, did I get that kite?
Okay.
He sent me more than one. He sent another one and said he got 7K. I could take that. I'll leave.
Where's that?
I don't know where it's at.
You lost it?
Nah. I sent it on out to my folks.
Okay. All
Sent it on
right.
out to my folks. My sister.
Okay. So you started telling the truth then. So surely by August, you met with the state in August 10th of 22. Surely by then you're telling the truth.
Yeah, I'm telling the truth.
And you would agree with me, the truth doesn't change. It's the truth, right?
Yeah, it's the truth. You know, quick brought me in and set me up for the police to camp me. So might as well tell the truth. If we gonna tell the truth.
Okay. So today, for the first time ever, you testified that you wiped that Mercedes down.
Yeah.
You've never said that before.
No, I ain't know.
You never told them. You never told them that you wiped that Mercedes down?
I never told detectives when I talked to them. Nah.
Why would you not tell them? They've asked you every question under the sun about this case, right?
I said detectives. I never admitted that I was involved to detectives when I first got locked up December 9th.
You know they take notes and they recorded your entire interview.
Right.
From August.
Right.
Why didn't you tell them in August you wiped the car down?
We were talking about so much, you know, we slipped my mind from.
And they specifically asked you, and you said,
They ain't asked me to get away from cutting. They ain't specifically asked me to
you
get away from cutting.
you don't recall them asking you and you saying, Justin said he had someone wipe the car down.
Yeah, he told me he had somebody to wipe the car down too.
But you didn't think to ask him,
I
right?
told him that I wiped it down. He said he used the right stuff, but I got somebody else to wipe it down. You know what I'm saying?
So now you're saying you told Justin that you went and wiped it down.
Yeah, I told him too.
Why didn't you tell that to law enforcement who's seeking the truth from you, right?
There was stuff slip a person's mind too. You know what I'm saying? Like
Kind of an important detail.
Like they ain't asked me to get away from cutting him, so
You don't think so?
I don't recall.
You text Miss Jackson, let's see, 9:05 a.m. on November 17th, 2021, you say, good morning. I went to sleep in the midst of texting you to knowing today is my big day.
My baby birthday. My daughter's birthday.
November 17th?
Yeah, my daughter.
You went and killed a man on your daughter's birthday?
Hey, I'm trying to make it right for her. I ain't have no money. I'm trying to get some money that day. So I'm trying to make sure my baby girl, man, have a beautiful birthday. So it was whatever. Then I'm trying to get high on pills. It was whatever.
But you're telling her you're going to buy her house, you're going to give her $10,000 for rent?
I said this
Right.
day before.
The day before.
Yeah, you know, I can tell female lies, you know what I'm saying? Like, that's my baby mama. I was trying to get back with her, whatever. It ain't just like, you know, it's just game. You know what I'm saying?
After Smith was off the stand, the state called Dr. Juliet Scantleberry, who performed young Dolph's autopsy, as she testified to the amount of gunshot wounds to the slain rapper's body.
Can you tell me what you see in that picture?
So this is the right side of the head and neck, showing a large wound on the right jaw.
Dr. Scantleberry, can you tell us what you see in that picture?
Yes. This is the back side of the body, noting mostly highlighting the right back with several wounds, and some wounds are noted on the left side of the back as well. And you can see the wound on the right jaw.
You can place that one down as well. As to exhibit number 18, could you tell me what you see in that picture?
So this is a front side of the body, highlighting the left side, and it shows some gunshot wounds here.
Okay, you can place that one down. And as to exhibit number 19, what do you see in that picture?
So this shows the right wrist and hand and a little bit of the forearm. and it shows some gunshot wounds. This one mostly highlights a wound at the right wrist.
Okay. And this is exhibit number 20. Could you tell us what you see in that picture?
So this is the wound of the left forearm right here, and it shows a gunshot wound of the left forearm.
And Dr. Stanberry, if you could just give me some clarification here. Are these white squares showing where there are holes in the clothing?
Correct.
Okay. Are there arrows on those white squares?
They are.
Okay. All right. And about how many holes in the clothing did you calculate?
I did not count those.
Okay. Thank you. And the next picture is exhibit number 23. Now, it looks like the same photo, but is this the front or the back of the shirt?
This is the front of the shirt.
Okay, and do those white squares also indicate holes in the clothing?
Correct.
On day 2 of trial, Johnson's friend Christian Garner, who was with him prior to the shooting, said he had no idea his friend was going to murder young Dolph.
Did you know what Straight Drop was going to do in that Benz?
No, sir.
Did you have any idea at all?
No, sir.
Were you part of this conspiracy at all?
No, sir.
Had you ever talked with anybody about killing Dolph or these other PRE artists?
I want to do this.
Why wouldn't you do that?
I want to do that one. That's my family.
You say that's your family, what you mean?
This party. That's my family. I want to do this.
Yeah, when you say it's not your family, though, what do you mean? You talking about family, who you talking about?
Young dog.
Young Dolph?
Yes, sir.
Okay, so you did not see Young Dolph as some sort of rival or anything like that?
No, sir.
According to investigators, the white Mercedes used in the killing was stolen by a man named Trayon Ingram weeks prior to the murder. And while Garner testified he saw Johnson get out of an Infiniti and into the Mercedes along with him, under cross-examination, defense attorney Luke Evans seemingly claimed Garner was well aware the Benz was stolen.
And you told this jury today you had no idea that Mercedes-Benz was stolen.
No, sir.
Now that just isn't true. And you know it's not true, right?
I wouldn't been in if it was stolen.
Okay. What's Trayon do for a living?
I can't tell you.
I mean, did he have a job that you knew of where he could afford a Benz?
Yes, sir.
He did. What'd he do?
Work at a garbage truck place.
Okay. What? I mean, you weren't with Trayon when he carjacked it a couple of weeks before. I mean, you and him were tight, right?
Yes, sir. If I would have been there, I would have said, no, I wasn't.
You weren't there?
No, sir.
And you just, I mean, how long you known Trayon?
My whole life.
You've known him your whole life.
Yes, sir.
He works at a garbage company,
Yes, sir.
right? He's driving a Benz. How long had he had the Benz?
I can't tell you.
I mean, you hung out with him almost every day, didn't you?
No, sir. You only kind of pick me up when I need a ride.
Did you need a ride the night you say you went over and traded the Benz?
Yes, sir.
Where were you going?
Off Redwood in a mile.
And Trayon was just taking it.
Yes, sir.
Well, what did you think when he was going to trade his nice bought and paid for Mercedes-Benz for an Infiniti Q40?
It's his business. That's what I thought.
Let me ask you this, Kristen. For Trayon and you riding around in this Benz that you thought he bought and paid for, didn't carjack to get it, what did you think when he was riding around with 2 pistols and a Draco in the back?
Text is me.
Because that's what he had, right? A Draco style assault rifle.
I can't tell. I just know he had some type of weapon.
After his testimony, another key witness would testify, and it would be another person close to the accused killer, his own half-brother. Jamarcus Johnson took the stand, also opting not to show his face on camera.
You are charged with taking possession of some of your brother's property. after the Dolph killing, and for aiding him to communicate with another man by the name of Cornelius Smith after the Dolph killing. Okay? You have an attorney for that case, is that correct?
Yes, sir.
And he's actually in the courtroom today.
Yes, sir.
You have pled guilty to being an accessory after the fact, several counts of that offense for taking control over a car your brother was driving afterwards, for taking control over a phone that your brother had afterwards, and for helping him by using the phone communicate with Cornelius Smith. Is that right? And you've entered a guilty plea to those offenses, but you have not been sentenced yet. Is that correct?
Yes, sir.
Meaning that a judge has not had a hearing and told you what your sentence is going to be. Is that correct?
Yes, sir.
Have I told you that it's a very good idea for you to tell the truth, and that the truth could help you at whatever sentencing you have one day?
Yes, sir.
Now, did you even know who Dolph was?
A rapper, yeah.
A rapper. Okay. So you knew Dolph was a rapper.
Yes, sir.
Okay. Did you have anything to do with some sort of plan on the front end to kill Dolph?
No, sir.
Is that anything that you would ever be involved in?
No, sir.
Any sort of plan to kill other PRE? Do you know what PRE is?
Yes, sir.
Okay. Any plan to kill the other PRE artists or anything like that?
No, sir.
Okay. In 2021, about how often would you talk or communicate with your brother, Justin?
Like every other week.
Like every other week?
Yes, sir.
In 2021, about how many times do you think you saw him that whole year?
Like 2 or 3 times.
Okay. So in all of 2021, you would have seen him 2 or 3 times.
Yes, sir.
Does that sound about right? And you would have talked to him maybe once a week or every 2 weeks. Is that correct?
Yes, sir.
All right. And again, just because the court reporter, like when you nod your head, I know I know it, but we got the court reporter, okay? All right. So it'd be fair to say that y'all were not close.
Yeah. Nah, we were close, but we didn't talk all the time.
Okay.
Yeah, there's stuff going on. I got my stuff.
Okay. Were his friends your friends? Okay. So did you know the people he hung out with? Did you know, for instance, Treon Ingram?
He testified after the murder his brother called him about wanting to hand over a rental car to him, something that wasn't out of the ordinary for him because Jamarcus didn't have a car.
Before this conversation about bringing you a car and stuff, when was the last time you talked to him?
Probably like 2 or 3 weeks before that.
Okay. All right, so you meet him in the car, he's got the 2 phones, and he's going back and forth with the numbers. Were you asking what he's doing or what's going on?
He was just quiet.
Okay. And what are you doing?
I was on my phone.
Okay. So you're sitting there next to him, you're on your phone, he's doing his number stuff. What happens?
He tell me he was gonna give me the phone. It was like social media stuff.
Like that he's going to give you one of his 2 phones. Okay. And you said for social media stuff?
Yeah, post some pictures, checking your emails and stuff like that.
Does your brother have social media?
Got Instagram, yeah.
Okay. In fact, you know your brother, does he go by other names too?
Other than his real name, straight up.
He gives you his phone. Because it's the idea that people may be calling or texting or messaging him.
You can say that, but it was just mainly he just told me that he needed me like to post some stuff.
Okay, so he told you at the time that he needed you to use his phone to maybe post some stuff to his social media. Was that
like videos, all that stuff.
okay? Did you ask him why he couldn't do this himself with his phone?
No.
Okay, but he has this phone in his hand. And he's going to give it to you, and you already have a phone. You don't need a phone.
No, no.
The car sounds good. And he wants you to have his phone and maybe post stuff to social media.
Yes, sir.
Okay. You don't ask him why. Does he provide any explanation?
Other than just for the social media stuff.
Okay. He doesn't say why he needs you to do this rather than him.
No, sir.
Does he tell you that he's getting out of town?
No, sir.
Does he tell you that he's got to lay low?
No, sir.
What happens after he gives you the phone?
Somebody was calling him and stuff, like rushing him to come on.
In the car there? So he's getting a phone call from while he's in there?
Yeah.
On one phone or the other, do you remember?
I don't know which one.
Okay.
Jamarcus testified he was a part of a three-way conversation between his brother and a man named C.
At the time, did you know who C was?
No. No, sir.
Do you now know that to be Cornelius?
Yes, sir.
Were you able to hear a conversation going on between Justin on one end of the line and Cornelius, since you all sort of three-way there?
Not like full conversation.
Not the full conversation. Were you able to hear some of the conversation?
Just a little bit. I won't really just listen.
Okay. You've been asked before whether or not you heard some of the conversation, correct?
Yes,
And have you described part of the conversation having to do with money?
Yes, sir.
Having to do with getting money to C?
The text message.
The text messages?
Yeah.
And what was it about?
It was like, he just kept saying like, "What's up, bro? What's up, bro?" And stuff like that. And I was texting my brother, and I was telling him somebody texted me, and he was like, who he is and what he want. And then when I told him, he kept saying like he loved him and stuff like that. And then he said, have you talked to Uncle?
Okay. Did you know who Uncle was at that time?
I said, he said, talk to him. Then he said, if you talk to him, tell him I need some money for my little girl's birthday party.
Okay.
Yeah.
And did that make any sense to you?
I really don't care.
About money, though.
Mm-hmm.
The money that would be coming from Justin and Unc to this C person.
I don't think it was coming from Justin. I think it was just coming from Unc.
Coming from Unc.
He was telling him to ask Unc.
Okay. So C was asking Justin to ask Unc where the money is. At the time, did you know who Unc was? At the time, had you ever even heard of Big Joke?
I knew he was, yeah.
Had you ever met him?
No.
You ever talked to him?
No, sir.
Okay, but you knew his name?
Yeah.
During cross-examination, Johnson's attorney kept it brief, only asking his client's brother one single question.
So you knew Justin to be an aspiring rapper,
Yes, sir.
correct? He was trying to get signed.
Yes, sir.
Okay. Had you ever, prior to that date, ran his social media or YouTube before?
Yes, sir.
All right, so that wasn't a new thing for him to ask you to do.
No, sir.
Okay. All right, thank you very much.
His testimony would mark the end of another day in court, as now 2 out of the 4 accused in the case have taken the stand in Justin Johnson's trial. While Hernandez Govan is accused of arranging the murder, he did not take the stand in Justin Johnson's trial, and the defendant himself chose not to take the stand in his own defense.
DeMarcus Johnson pleaded guilty to 3 counts of being an accessory after the fact. He still has yet to be sentenced in the case and faces anywhere between 6 to 12 years in jail. Hernandez Govan and Cornelia Smith both still face trial for their role in young Dolph's murder and face the rest of their life in prison. And for Justin Johnson, he too could face the rest of his life in prison if convicted. Reporting for Law and Crime, I'm Elizabeth Milner.
Thank you all for coming today. I want to start out this morning by introducing those that stand with me. To my far right, left, and your right, and who you are.
Yes. So that concludes our young Dolph murder trial for today. It ended in Justin Johnson being found guilty and sentenced to life in prison. Another young life gone. So as community, we gotta do better. We have to do better. You know, my cousin and I, y'all may not be familiar with, when I bring in elements via any way I can of me, like my family, my friends, things of that nature. And just to, hey, share, like, this is how we do it, right? And I've always said that in my family, and I've seen the families of others, and I've seen the results of others, is that somehow boys are treated so much differently than girls are treated. That's from coming up to growing up, right? And becoming an adult. They just, oh my gosh, they get a pat on their hands for, stuff when they should really have gotten punished. And with girls, they be so tough on us, right? But not with the guys. With the boys, if they have sex early, even Denzel said, when, like, he'd be like, atta boy, or not with his girl. Like, what? You did what? And they give you some sexist reason, rationale as to why. But in the long run, this is what happens. Mothers aren't being, responsible and accountable for their children. I know here in Florida, and I think some other places, it's a lot of accountability that has started, right? You're seeing mothers and fathers getting arrested or getting held responsible when their kid come and shoot up somewhere, right? Hey, you gotta start somewhere. But it's really, I don't get it. I don't get it. And I'm lucky. It's lucky that my family is just hard on us, period. But the hard on the boys it doesn't compare to the girls, but it's better than what I've seen other families do. So that's why they, turned out pretty good. But It's crazy. They make excuses for these boys, these men. The mamas do it, the wives do it, the girlfriends do it, you know, all kinds of stuff. It's, and what I've routinely seen is that it always ends and it's some bad, the ending is always bad when it's done like that. Okay. For me, I hold anybody's feet to the fire. And I want people to do the same with me. A lot of times, some people will be like, oh, I'm scared. No, tell me what you got to tell me. Be upfront and let me know. Because I'm a person that want to do the right thing. I'm a person that's okay about hearing the the cold truth, right? I'm not gonna get upset as long as you got it right, as long as it's coming from a good place and from the right person. Put it like that. Yeah, somebody who care and love. Yeah, anybody else, I'm gonna be looking, sideways. Like when certain people would say, they don't want me to argue, and certain people say, are different people. These are different people. Oh, you should stop with the back and forth, whatever. I'm looking like, but I never hear them tell the other person, and and largely that's because they down, whatever. I don't listen to no people like that. I'm like, child, I just be forming my opinion about their ass. I'm like, oh, and you gonna show your true colors. I'm gonna be right here and see them, and then I'll be like, ain't bad shit as I suspected. And as everyone knows, and that's okay. And here's the thing, right? They ain't about shit people. They okay with being ain't about shit. So that's why I'm okay with telling them. They know that. They know that. It's not a secret. Yeah. But I might just put it in a way that may be offensive, but I'll tell you, you ain't about shit since you was knee high. You been about shit. Now, anytime you don't have a sensitivity to when you have wronged someone, that's just one example. You ain't about shit. It's my opinion. No, and no, and it's backed up a little bit by science. It is when you start describing some of those conditions. Yeah, sensitivity, emotions, all those type of things come into question. But we're not having a psychology class because the smartest girl, the most informative girl on the planet isn't in here. And those people, information specialists are a blessing to me, right? I'm telling you, they make my life so goddamn easy. But yeah, they treat these boys like, my friend had have a son who had gotten kicked out every school and the alternative school. And every time you turn around, she talking about she had to leave her job, and it's when but it's something that they picking on them at, like the teachers and all of that. They gonna risk their job to pick on a child. If they have them one time, yeah, but your kid keeps getting kicked out of all the schools. And then what was his final schooling? Y'all should guess, the Florida State Prison. See, that's what I'm talking about. You did the shit. You have freedom of speech and you have freedom of choice. I don't know why nobody don't understand that, and anybody that says anything different and try to say blame their actions on somebody else and all this extra bullshit ain't about shit. And I'm pretty sure I got the evidence to prove it. Ain't about shit, and I just don't even understand how ain't about shit people serve or not serve, but be that's allowed on this planet for so long. They in the way. I ain't saying like maybe they can go over there, like get a space shuttle or something. Maybe somebody can take an accounting of their service, add it all up. I know they ain't gonna come to shit. And just, let them going on over there in the space shuttle program and shit and go on fuck around on the moon, Mars, wherever before they go at. And get out the way. We have products like Trump and shit, like get out the way. Just, shut up. I'm not their favorite, but I'm y'all's favorite. I'm everybody's favorite off him. But I'm serious. That's how I look at it. And listen here, and I'm real flexible. I'm the person that would say, hey, I'm okay with you stopping being the fucked up individual you are and then start on a road of doing good, being of service, being an assistance to somebody, not a motherfucker that's just here to cause chaos. Now, if something is wrong with your ass, I make those allowances for you too. Go get you some geodone and shit. Go get something and sit down and get out the way. Yeah, or play with them little blocks or something that that the only thing you'll be able to play with after they hit you with that geodone and get your shit regulated. You know? You can't blame shit on nobody else but you if you are the one that did it. I don't understand none of that. Just say conspiracy. Just say co-defendants, right? If you did it and they did it, it doesn't matter who told you to do it. It doesn't matter who you saw do it. It doesn't matter. None of that. You did it. So you need to be responsible for your own actions. What happens is that based on your level of responsibility, it may be, your liability may be mitigated. Damn. No, they want everything. No, I saw them do it, so I did it. They told me to do it, so I did it. What kind of bitch ass shit is that? Or weak ass shit is that? You weak minded. If you can't pick to do right but do wrong, cause it's out there to do, you weak man. You a follower. You need to go on. You in our way. We the people that's meaning to do something. You're in our way. And understand this. Everybody that I fuck with, friends and anybody else, we both have some type of the same. Mine may be a little different or whatever, but we all kind of feel the same. You're in the way, and because we are a community, we don't let each other slip in those type of. I mean, we don't slip in those type of, in those type of grooves anyway. But it's always somebody, not nobody, okaying it. You understand? I'm saying, like saying it's okay. It's okay. Yeah, you can be a piece of shit. It's okay. Hey, you please, by all means, be a piece of shit. I love piece of shit. No, it's okay. That's okay, buddy. Be a piece of shit. Like, huh? I can't. I never will. Mm-mm. Mm-mm. I don't even understand it. Like, what? How this work? Trash booker. We run it like it's the military. I run my life like it's a business. I'm going to expand on that. I'm going to change it a little bit. Because I just said something I like better. I'm going to run my life like it's a military business. How about that? That way, people can understand what I'm saying, and I ain't got to give much explanation about it. I'm going to change it a little bit. A military business. That encompasses a lot of things. For so long, me and whoever I'm, dealing with in my bed, or I'm in his or whatever, or in our bed or whatever, right? We will be laying down thinking and coming up with progressive shit. We ain't always laying trying to get it and all that type of shit. No. One day I'm gonna have that boy go get that treasure trove of awards. He can get sick. Yeah. Like we are real live heroes, not in theory and fantasy and all that. No, 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 no. We got to, and then don't get mad at that. What you want me to do? Show right ass. I ain't got nothing to do with that. I don't know y'all. That's what the award says. That's what the paperwork says. That's what them damn dinners say. For these type of people, come on in. Then putting in the work. Even when you listen to OG Tiller, even though he tell you what his business was, he also tell you that, he's had a business all this time, and he was out there talking about doing good, helping. Even in a position to where it's very easy to think about yourself, he's thinking of others and himself. That's what community does. Spread the word. Have conversations that generates education. Yeah. It's crazy to me. And then they get mad at people what understand say, oh that you be like people I'm, accustomed to, they be like, oh, you're doing good. This, that, that. Not these motherfuckers. That's because these motherfuckers, yeah, baby. I can't say what I want to say because it's offensive as hell. But just believe, I be thinking it. And you see the look on my goddamn face, when it's swollen, well, it's always swollen. But baby, oh, I be like, oh Lord. I used to anyway. Mm, 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 mm. But nothing. Oh damn. Oh, jeez. Waste of space and time and energy. Worrying about the wrong fucking thing. Glorifying the wrong fucking thing. That's crazy to me. Mm-mm. Weirdo. It's so easy. It's and a lot of these things can start the process of eradication right where you are. You sit your motherfucking ass up here online and not even understand it because you're too dumb or whacked out your motherfucking head or worried about bullshit or high, drunk, hungry, and all this extra motherfucking bullshit, mentally ill and weird and shit, and then not even thinking that that's your community right there. Why not start with the good word, not your biblical word? Because you motherfuckers shouldn't even. I told you I get offended when you play with the Lord. Don't worry about it. I think brother Jeff, maybe brother Jeff, and I'm gonna give Atmos a pass, and I think they'll be our they can speak on the Lord, yeah, in the right way. You understand what I'm saying? And what I mean by that is I don't want to see nobody talk about, they love the Lord thy God. I'm gonna fall out and pass out due to his goodness and all this, that, and the third, whatever. In the next minute, you doing fuck shit. I don't get out like that. That's what I mean. That's one example you playing with the Lord. Mm-mm. So don't do that. So I don't. I don't have to hear nobody talk about the Lord anyway, because I don't. Nobody talk about the Lord. I'm just saying from the past. It is, these Bible thumpers. Because they go to the church every Sunday or another day during the week. Tuesday Bible study. And raising hell the rest of the damn day. What kind of shit is that? And having all kind of fornication, sex, and all this here, and doing all this extra. The hell? Don't complain. And then they'll use it as a tool to try to manipulate you. Pimps do it. Men that want women to be submissive do it. But when I have time, I don't like to read. When I have time, I'm going to start getting it. Reading that Bible, I'm going to get very familiar with it. And I'm going to figure out who said what and what's right. Because I need to trust interpretations. Okay? So if I don't trust you, I'm not going to trust your interpretation of the Bible. And I rely largely on other sources. If I don't trust you, I'm not going to trust your interpretation of the Bible because I already know you ain't about shit. So your interpretation is going to be bullshit or manipulative, one-sided. Da, 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 da. Go out and go on, right? So and that's just what it is. You just. Uh-uh. Or if you're a little cuckoo, and we're gonna have a cuckoo interpretation. I don't want that either. Be some weird shit. Like what? Oh Lord. I mean, like now I know damn well that is not. Cause it's some modern day. Uh, uh, uh. Now wait a minute. You know. Listen, I'm trying to tell you that people picking process is the foundation on everything. Even with the shit I listen to. Because I can't trust your commentary, your shit. Well, no, no, no. So I get, I subscribe or unsubscribe to this, whatever, to a lot of these different, and thank you for that because I get different audience. Somebody told me how to do it, and child, I know what I'm doing, but yeah. This world, I'm sorry, not, well, I can say this world, but I'm really talking about America. America has been set up centuries ago to have certain people, elected or not, control us. That's the way it's set up. You can look at that through your political, judicial, business, and so on and so forth. Right? It's set up for certain people, elected or not, to control us. Okay? So, we at some point have to make our own difference. And hopefully, in making plans to make our own difference, you think that you're gonna think about doing that for not only yourself, your family, your friends, your next door neighbor, whatever, so it could spread. And then hopefully the next set of people that are put in position to control us are carrying out our agenda and not the agendas of a divided people. We got every kind of classification, category, party, whatever you could think of, religion, whatever. I'm not saying should we all be as everything we think of that's crazy. No, 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 that's weird. But the goal should be a better world for everybody. That means you got to include people you don't even like. You got to include people that don't even deserve it. You got to help them when they can't help themselves. See, this is the information I want church people to tell me. I should be the student of the church people. Instead of them, doing all that collection and prosperity ministry and all this extra stuff they be doing and casting out the demons and talking crazy and all that stuff. We can go down the line. I need you to get practical and come down here. I don't know what Pastor Keon actually be saying all the time, but I think, and I may be wrong, so I'm gonna leave my opinion open on this, right? Open to to change whatever I get additional information that says otherwise. But I like someone like Pastor Keon that's not too holy, that's practical, and it seems like from what I see that he's trying to do the right thing by his people and by his life. I don't know, but he seems like a person that hasn't letting the religion drive them crazy. Because you know those people that have letting religion drive them crazy. You understand what I'm saying? So, but yeah, that's just what I feel. When you have people that have a problem, but the way you feel, or hell, you got people that have a problem about your past life, your present life. I don't know what it is. It's crazy, honey. Weird. Just weird people. Like, what the fuck? Like, what is the problem? I ain't never felt like that about nobody's. Like, I don't care what picture, who you call. I wouldn't give a damn. I ain't saying I got something to say about it. Like, oh, that is hater in the first degree. And then you got the followers that take. And here's the thing, right? And this is another thing. This is a thing about a follower. Now, tell me the people that are 50 and then some. Then your parents instruct y'all about not being a follower. And then your parents tell you about followers, right? But another thing, what happens to followers? Followers always the one that get in trouble. And my favorite follower is the one that get their ass beat or embarrassed. They sit up there and let somebody put that jumper cable on them and they be doing this extra shit, whatever. And then somebody run to their ass and hit them with the they be like, oh, and act like ain't never nothing happened. Oh, I ain't see that. Like, what the fuck? You saw it. Oh, Lord. Because they followers. Oh, I ain't, huh? There ain't nobody. Can't nobody. And it is such a, it makes my skin crawl. Weak, because, followers fall in the category of weak. And my child tell you, she be like, oh, what you think I'm weak? She know I hate them motherfuckers. I do. And they just, that's a pet peeve of mine. You weak motherfucker. You weakling. That my family calls it, a weakling. You a weakling. okay. Which one to jump off the bridge? Okay. I'm like, my mouth be open. I can't do it. I can't do it. Oh, I'm a goddamn fool with him, baby. Uh, mm, 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 mm. And they do it without any shame. Without any shame. You're so weak. God dang. Mm, mm, mm. You know, I ain't for everybody. Everybody here ain't. You know what I'm saying? But in my world, um, apparently I am. Because they are a different type of people, you know. They real good folks. And knowing what I'm saying isn't harming anybody. It's helping, right? I'm not saying nothing to harm nobody. I don't show nothing. I don't put a picture up or call nobody whatever to harm nobody. Like, how, what? These motherfuckers think it be like that I done harmed they motherfucker. No, what it is, you know, you can't fuck with me. Never ever could. And you're mad. And you're just like, oh, she's trying to. No, I'm not. Follow my story. This is my goddamn channel. I don't say nothing when nobody do whatever they put up and doing whatever. I ain't got nothing to do with that. I don't give a fuck. Nobody can never say, oh, you did this, you did that. Find it. Oh, you put that in your channel, you did that. You had this on, you did that. You put this out, find it. I do something, baby. It's a motherfucking goddamn conference call party. Like, goddamn. Like, damn. Yeah, baby, I know what it is. As if you was bat shit. I can go several different ways with that. If you was bat shit, you would have. Yeah, it was bat shit. That shit wouldn't even bother your motherfucker. Like, what the fuck? That's crazy to me. Crazy. Well, I get it though. I'm sorry, Twitter. This probably doesn't uh apply to y'all, but the message is still the same, right? But yeah, I get it. Damn, you trash, and I know it, and you know it. Especially when you cut that light off at night, you know it. You are a piece of fucking trash. Mhm. That's what it is. Not my goddamn fault. And let me tell you something. And it has nothing to do with, well, not being trash won't allow you to do everything. That doesn't mean that you will live perfect. Of course, you gonna do some shit. It's just how you feel about doing it and after you do it and different things of that nature, right? But then certain things you can't even do. So, um, so I'm, so there's some drug dealers that won't sell to um, pregnant women and shit like that or whatever, things of that nature. Yeah, y'all know how that shit go. I mean, there's some will sell any goddamn body, you know. That just like in Scarface, he said he's not blowing up no children. He ain't blowing up no kids. He ain't doing that. He a killer, but he ain't killing no kids. You understand what I'm saying? That type of shit. So, it's just, yeah. But, hey. Mm, 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 mm. It's upset my stomach. Ugh. Right. Now, this is the part where I am 100% my family's kinfolk. Whew, child, ugh. But I be struggling to find your motherfucking goddamn, I be struggling to find your damn, uh, mm, shit. Mm, mm, mm. You know, taking a kid down, they kids living or dying, or what the fuck kind of shit is this now? Like, I be like, who told you that was okay? They make excuses for blame it on somebody else. The reason why they do the bullshit they do instead of blaming it on that person. And then the motherfuckers be going along with it. I be like, just some big old collection of trash on Saturday that just need to be pulled to the end of the street. Ah, see, here's the thing about me, right? You're not gonna say anything to me. I don't give a damn if I'm in a conference or whatever, right? You're not gonna say something that I disagree with, and I'm gonna wait. Hold on, I'm change that. You're not gonna say something that is just, huh? And I don't. I'm gonna first question you. I done gotten better now. I'm gonna first make sure that I'm clear on what you're saying. Then I'm gonna let you know what it is. I'm just not gonna go along with it and then give you all these justifications. That's why how you end up with these men and these boys getting taken off these streets by the people. That people are mad because the people are coming to arrest. They mad at the people that's arresting them, but yet they don't understand that as a follower, as a do whatever, you are aiding the motherfucker. You help walking them up to the door to the people. And who you mad at? Child, please. Wait a minute. Oh, this motherfucker up. This trap. Yes. 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 I am 100% better than you motherfuckers. Yes. I said that. Ain't nothing you can do. Ain't nothing you can do. Ain't nothing you can show, put, nothing. It's still going to equals the same. Mm-hmm. There's a lot of people that can say that. They just chose not to. I don't. Instead, hey, they be acting like, or they on the under some kind of secret. You know, they let me know, Miss Angela, I'm about shit. Hey, they hit me up like, Miss Angela, you know, I'm about shit. I just want to let you know. I agree with what you say. I'm about shit. I surely am. I surely am. You're exactly right. My family them and my mama them and I got good sense to do the right goddamn. Ooh, what? I mean, you got to know to do the right thing and knowing that when you do the wrong thing, then know it is the wrong thing. And that's it. Not these no good motherfuckers. And I hate to say it, like the mothers, I mean, it's the women that be aiding in this process and then cry when the motherfucker come pick the man up. Oh, they trying to get the man out the house and all this that, and the third. Huh? Nobody's actions did that. Like what? You know what? And one thing about, and this just a region thing, or maybe this just people I know thing. My daddy and other people. They got caught. When they get caught, hey, they ain't got no excuses. Ain't nobody made them do it. They mitigation report, shit, it's as a matter of fact, I'm gonna tell you what it is. You know, somebody try to get it the lowest. But that's another thing. It all depends on who your mouthpiece is too. that makes a difference. If your mouthpiece is the old state's attorney or something, all that type of shit, you know, it makes a difference too. But still, it's great. Yep, I'm gonna change this thing. I have to go on my damn platform real quick. I run my life like a military business. I like that. That's hot. Mm-hmm. My partners, we on that same way. I love it. And they always somewhere where making a difference is topic, you know. Hmm. But anyway, y'all, what time is it? 8. Kind of too early to get off. Get off. All right, y'all. I don't talk too much shit for today. people on Twitter is still there. That's just crazy. In a good way, though. So guess what? Make sure you do something good for yourself and someone else. Stay live to the next live. Let me see how I come with something else. Something really like that. Oh, I know what I can say. All right. Do something good for yourself and someone else. You be the change so we can make a difference. And oh wait a minute, I got two buttons. I gotta hit to get it out of here. What I said, okay. Do something good for yourself and someone else. You be the change. You be the change so we can make a difference. And I am out of here. And so are you.